We tend to think of laws as these super carefully crafted rules, right? But what happens when a law is so badly written it just creates total chaos? Or what if it's so outdated it becomes this zombie law that just refuses to die? Well, today that's exactly what we're digging into. We're looking at something called choice of law statutes, basically the rule books for which rules to follow. And oh boy, some of their failures are spectacular.
All right, so here's what's on the docket. First, we'll cover why these laws even need to exist. Then, get this, we're going to dissect a federal law that was so poorly written, someone actually called it completely inept. And you'll see the clever, kind of sneaky gimmick the Supreme Court had to come up with to fix it. We'll also look at laws that were basically obsolete the day they were written, and others that, still haunt our legal system like zombies. So, let's jump right in.
Okay, so let's start with the basic problem, right? Picture this. You buy something online from a company in another state, or even another country, and it shows up broken. So whose laws apply? The rules where you live or the rules where they're based? Or, hey, what about a car crash that happens right on a state line, and the drivers are from 3 different states? You can see how this gets super complicated really fast, and it all boils down to one critical question.
I mean, without a clear answer here, you just got chaos, right? Businesses would have no idea how to operate, and people couldn't get justice. So to solve this whole mess, the legal system came up with a pretty special kind of tool.
It's called a choice of law statute. Think of it like a legal referee. Its only job is to step into a messy situation, blow the whistle, and decide which jurisdiction's rulebook we're going to play by. Sounds simple enough, but what happens when the referee itself has no idea what the rules are? Well, that's when you get a complete and total breakdown.
All right, so for our first cautionary tale, let's talk about the Federal Tort Claims Act. Now, this is a big one. This is the law that actually lets you sue the U.S. government. You'd think a law that important would be written with, extreme care and precision. Yeah, you'd be wrong.
I mean, listen, you don't often hear serious legal scholars throwing around words like completely inept. The fact that they did tells you everything you need to know about how disastrous this law really was. So what was the fatal flaw? What was so wrong with the way it was written?
Okay, so the rules said that liability would be determined by the law of the place where the act or omission occurred. On the surface, that sounds simple, right? But think about a plane crash. Was the act the faulty design that happened in a California factory? Was it the negligent maintenance that happened in Kansas? Or was it the crash itself in Missouri? See, this one little phrase was so ambiguous, it created an absolute nightmare for any court trying to figure it out.
And here's the real kicker. A curious judge actually went back and tried to figure out why the law was written so poorly. And what did he find? Some deep, complex legal reasoning? Nope. He learned that the drafters just kind of thought that was the standard way to word it. A simple mistake. A, well, we thought that's how it's done moment led to decades of legal headaches. And it got so bad, only the Supreme Court could figure out a way to fix it.
So this creates a really interesting puzzle. How do you fix a broken federal law when you can't actually rewrite it? The Supreme Court can't just change the words Congress wrote. So they did the next best thing. They changed the meaning of the words with this brilliant legal workaround, a gimmick really, that finally made this inept law work.
See, the original problem was that courts were trying to apply the substantive law. So in our plane crash example, that'd be like grabbing Missouri's specific safety regulations, and that's it. But that approach was way too rigid and just didn't work for these messy multi-state cases. So the Supreme Court introduced a subtle but incredibly powerful twist. So here's the gimmick. They called it quasi-renvoi, but don't worry about the term. The idea is simple. Instead of just looking at, say, California's safety rules, the court said, no, look at California's whole law. And that whole law includes California's own rules for choosing which law to apply in a complicated case. So the new instruction was basically, go to the state where the act happened and ask that state's legal system how it would solve this exact kind of messy problem. It's like asking for their entire playbook, not just one page.
And this one tiny change, it was everything. It took this misshapen abnormality, as one person called it, and turned it into a working system. Suddenly, courts weren't stuck with one rigid, unworkable rule. They were now free to use more modern, more flexible legal thinking to actually find the fairest outcome, all just by reinterpreting a single, poorly written phrase. Okay, so bad wording is one way a law can fail spectacularly, but it's not the only way. Sometimes the problem is way deeper than that. Sometimes the entire idea behind the law is just flawed from day one. Usually it's because it's built on social values that, well, simply don't last.
Just look at these two examples. First, you had pre-Confederacy statutes that, just bizarrely, tried to classify enslaved people as property, or immovables. It was a moral and legal inherent contradiction from the start. Then, much later, you had something called the Uniform Marriage Evasion Act. It was designed to enforce a very specific, rigid view of marriage across all state lines, but its creators just completely misjudged where society was headed.
And this right here leads to a really unsettling problem. What happens when everyone agrees a law is a total failure, but nobody actually gets around to repealing it? Well, you get what I call zombie laws, statutes that are officially obsolete, but are somehow still on the books. Remember that Uniform Marriage Evasion Act we just mentioned? The organization that created it officially declared it obsolete, a failed experiment. And they did this back in 1943. 1943. We're talking decades and decades ago. So you'd think it was repealed everywhere then, right? Nope, not even close.
Incredibly, as of today, that exact same obsolete law is still on the books. In how many states? 5. 5 states still have it. It is the perfect legal zombie, officially dead for decades, but still shuffling around in our law books. It's an amazing example of just how hard it can be to clean up old legislative mistakes.
So let's step back for a second. What's the big picture? Why should we care that some of these kind of obscure statutes are poorly written or totally outdated? Well, because it reveals this fundamental and fascinating tension between the law as it's written on paper and the real world we all live in.
So what are the big takeaways here? First, that laws aren't this perfect, infallible code. Not at all. They can fail because of inept drafting, basically a typo. They can fail because the core idea is just outdated. These failures mean courts sometimes have to get really creative, reinterpreting laws and inventing gimmicks just to make them work. And maybe most disturbingly, we've seen that repealing old, minor laws is surprisingly and sometimes scarily difficult.
And all of this leaves us with a pretty big question to chew on, doesn't it? We rely on the law to be the stable, predictable foundation for our society. But if the laws themselves can be so inept, so outdated, and so hard to remove, it really makes you wonder, right? How much of our justice system truly relies on the black and white text of the law, versus how much of it depends on the constant, clever, and sometimes desperate human effort to work around all its inherent failures?